Now, John asked me to give you a summary or an update of what's happened in this past year, so I'll start at the beginning as soon as I find my little clicker, and hopefully we have slides. Perfect. January 5 of last year, the Supreme Court ruled that teachers are right. Article 9, Section 1 confers on children in Washington a positive constitutional right to an amply funded education. The Supreme Court also affirmed that everything we've always been saying about Article 9 is right. Under the paramount duty banner, it is the paramount duty of the state to make ample provision for the education of all children residing within its borders. Our state Supreme Court said paramount means paramount. Our Constitution requires the state to amply fund our public schools before any other state program or operation. Ample means ample. It's considerably more than just adequate. Education. Education isn't number of hours sitting in a seat. Education is the knowledge and skills our kids need to compete in today's economy and meaningfully participate in our democracy. And all kids means all kids, each and every kid in our state, not just the ones that are easy to teach, not just the ones that are in better communities or from better families, every single child. All children does mean all children. Our Supreme Court also then explained another important point and explained that the teachers are right about something else. And that's that the state is violating this constitutional right of every single child in our state. And the court went further and said, this court cannot stand on the sidelines and hope the state meets its constitutional mandate to amply fund education. It is our responsibility, the Supreme Court's, to hold the state accountable to meet its constitutional duty under Article 9, Section 1. For decades, we've heard about holding schools and holding teachers accountable. Here we have the Supreme Court saying we are going to hold the state accountable. Now, there's one thing I do want to emphasize about this, the state and the Supreme Court saying that, and as my kids would say, I'm going to keep my eyes on you. The Supremes are going to be watching the state. This is a big deal. The state Supreme Court hasn't done this before, but it's also a delicate deal. The judicial branch feels very uncomfortable telling legislators what to do, especially when what they're saying is spend a lot of money. So this is a delicate deal. We have to be careful as we're proceeding, and I'll talk about how we are going to be proceeding. We have to be careful not to push reluctant Supreme Court justices over to the side of saying, well, we give up and we're just going to punt to the legislature. As my college roommate used to say, less than delicately, pigs get fat, hogs get slaughtered. We have to be careful with what we do to make sure the Supremes stay on our side, which now brings us to the second ruling last year. And this is in July. The Supreme Court entered an order. You notice it's an order. It's not a suggestion. It's an order. And the Supreme Court's order said that, we're not kidding. To end the state's violation of Washington children's constitutional rights by 2018, each state budget must do two things. One, demonstrate steady progress implementing the education funding reforms of 2261. And two, show real and measurable progress towards achieving full compliance, not partial compliance, full compliance with Article 9, Section 1 by 2018, not by some far-off distant 2050, 3000, 2018. So we then get to the next question, did the 2012 budget show that progress? And that then brings up the question, well, what would steady progress implementing 2261 look like? Well, let's just look at, for example, per pupil funding. And let's start when 2261 was passed in the 08-09 school year. And at that time, the state's per pupil funding was $6,648. So that is the starting line for showing the steady progress. Well, now let's go to 2018, which is supposed to be the finishing line. And what would the funding be under 2261? Well, we can come up with all the numbers we want, but I don't have to because we have the state's own testimony in the McCleary case. The state's own testimony was that the funding reforms of 2261 plus the salary adjustments, which are going to bring state funding up to market rate salaries, is $12,546 per kid. That is the increase of funding that we should see under the state's own testimony. So that would be a minimum finishing line. And I say minimum because under the state's own testimony, that number excludes two things. Any inflation after 2007, I guess we're not going to have any after 2007, and any capital construction needs. So apparently, we're going to go to full-day kindergarten, but we're not going to build the classrooms to put them in. It excludes all of that. So this is just a minimum finishing line. So what would steady progress look like over this time frame? Well, let's just do a linear line, not a logarithmic slowly, and then jumping up, but a linear line. And that doesn't mean fully fund everything the first year, but over the course of years, you get a stair step going up to what the state's own testimony was. And you can just do simple math and fill in the numbers there. And so that is what, under the state's testimony, steady progress would look like. So let's now go to, we're in 2012. The Supreme Court has said that the state has to show steady progress. So let's look at the progress the state made after passing 2261. We go to the most recent budget that was passed, and there's their progress. You see, they made a bunch of cuts at the beginning, and then they're robbing from Peter to pay Paul to try to get back then up to where they were starting from. So then that raises the third ruling of the Supreme Court this year, which was December of this past year, and another order, not a suggestion, not like a slap on the wrist, but an order. And the question is, well, did the state comply with the court's order? And the Supreme Court said, no, the state's 2012 budget failed to do what the court had ordered. So now to try to translate into the language that, I guess, the certain legislators that think everything could be best assessed on a letter grade, the Supreme Court gave them an F. The Supreme Court then said, the state's 2013 budget must make real, measurable, and steady progress that was ordered by the court. And to avoid arguments that, well, we need more time, the Supreme Court said, and this is a quote, 2018 remains a firm deadline for full constitutional compliance. So then that raises the next question I know you're all thinking is, well, will this year's budget show that real, measurable, and steady progress? Well, here's the progress that had been made up until that ruling. And let's look at, let's say there's some people talk about we're going to add as our down payment $1 billion, which of course means since it's a biennium, it's only $500 million a year. That's what that progress looks like. Other people say, well, we're going to put a big down payment, $1.5 billion biennium, which is $750 million a year. That's what that looks like. Other folks say, well, look at the Joint Task Force on Education Funding. They've got a long-term plan, and it does have a longer-term plan, which shows more funding. I mean, all of this is going in the right direction. It's better than it was before the rulings. It is progress in that it's going that right direction, but it's not steady and it's not going to get us there by 2018. So then the question is, so what? What's the court going to do? Well, the court has declared the constitutional right. The court has said that Article 9 imposes a judicially enforceable affirmative duty to which the court can hold state officials accountable. And it is our responsibility to hold the state accountable to meet its constitutional duty under Article 9, Section 1. And what the rulings in this case also make clear is why this is so important. And that's because public education matters. The state never disputed, never even appealed, the trial court's rulings in this case that a healthy democracy depends on educated citizens. Education operates as the great equalizer in our democracy, equipping citizens born into underprivileged segments of our society with the tools they need to compete on a level playing field with citizens born into wealth or privilege. And that education, under that picture there, is the #1 civil right of the 21st century. The #1 civil right. Now, this isn't the first time a court has told the state's elected officials that the Constitution requires them to do something with their public schools that, well, the state officials really don't like. And over the course of the civil rights struggles, courts across the country have made it clear that the courts do have tools which our court can employ if the legislature acts in ways that upset and dismiss the Supreme Court enough. For example, courts can fine legislators for contempt. The court can nullify state payments for specific non-paramount items. Remember, if paramount duty means you have to fully fund the schools first, what are you doing paying for like laundry bills for legislators? Or if we're not going to fund salaries for teachers, well, let's not fund salaries for legislative staff. I mean, or legislators. The court can order property sold to fund compliance with the court's ruling. The court can prohibit the state from limiting an education program to less than all eligible students. So, for example, all-day kindergarten or lower class sizes. All kids, not just selective 1% here, 1% there, slowly increasing. The court can order the state to fund specific education amounts, and the court can issue what's called a writ of mandamus, some fancy legal term, that compels the legislature to perform. Eventually, people, elected officials like George Wallace, do step aside. It's not quick, it's not easy, but it's worth the struggle. 41 years ago, Lyndon Johnson made his last public appearance, and it was at a civil rights symposium in Austin, Texas. And his closing words apply to us here today as well. He said, "We know how much still remains to be done, but if our efforts continue, if our will is strong, if our hearts are right, and if we keep courage as our constant companion, I am confident we shall overcome." This is not going to happen by itself. Instead, John is exactly right. In our Supreme Court, in our state capitol, in each and every one of our local communities, it's up to us. I will continue this fight. I know that each and every one of you will continue this fight. But the road is long. The hurdles are high. The challenges are great. But I also know that working together, we shall eventually overcome. Thank you very much.